So, all the way back in 2018, it was a very different time. It was before anybody heard of Wuhan, it was before anybody heard of COVID. Trump was the president, and he tweeted back then, I think when it was still called Twitter, that he wanted to sign an executive order that would eliminate birthright citizenship. Interestingly, at the time, the Speaker of the House was a Republican, Paul Ryan, and he spoke out against Trump's planned move. He said, "You cannot end birthright citizenship with an executive order." Well, Trump is now, in just a few weeks, going to be back in the White House, and it seems like this is on top of his agenda again. It sounds like he wants to eliminate birthright citizenship. So, what is birthright citizenship? Where does it come from? And what could or could not Trump do? So, birthright citizenship actually was started in the year 212 in the Roman Empire by the Emperor Caracalla. He issued an edict in 2012 AD that granted citizenship to all free men and women, including people born anywhere in the vast Roman Empire. Why would he do such a thing? Well, he did it to spread the burdens of taxes, because if you're a citizen, you got to pay up. And it required public service also. At the time, there were only so many Romans that were native, and they had to shoulder all the taxes and do all the public service. So he opened this up, and now people had new rights but new responsibilities. So many of the new citizens looked different. They had darker skins, they spoke different languages, but none of this seemed to matter to the Roman emperor, because he thought that by expanding citizenship, the Roman Empire would expand its economy and expand its influence. This is how it's portrayed by Michael Leroy at the University of Illinois Urbana-Champaign. Fast forward to the United States. Where does birthright citizenship come from? Well, citizenship in general is a concept that we have to discuss, because the original Constitution was drafted with holes in it. You might know that, for example, the Bill of Rights, the first 10 amendments. Why are they amendments? Because the Constitution originally did not have them. And the Constitution was ratified really on condition that the first thing that the first Congress would do was amend it to include a list of rights that the government had to protect that belonged vested in the people. The framers of the Constitution had to deal with the fact that different states held different beliefs. Some states were free states, some states were slave states. And so there was no consensus as to slavery as an institution, and the word is not mentioned in the original Constitution. And similar to that is the question of who is a citizen. Is a slave a citizen? Is it a person? Is it a piece of property? This is what they had to deal with when they were drafting the Constitution, and they had to be vague and leave out certain things in order for the Constitution to pass among large portions of the original 13 states. Originally, there was no concept of citizenship within the wording of the Constitution. After the Civil War, there were the 13th, 14th, and 15th Amendments that were passed, and those sometimes are called the Reconstruction Amendments because they were added to the Constitution after the Civil War in a post-slavery America of 1868. So the 13th Amendment, interestingly, is the only amendment that individual people can really break. Usually if you go to Starbucks and you apply for a job and they say, sorry, we don't hire people of your national origin, we don't hire people of your gender, we don't hire people of your religion, is that unconstitutional? Well, no, it's illegal, but Starbucks is not a government entity. It's not a government-run program, right? It's a private corporation. And so there are laws against that, but it's not unconstitutional because the Constitution, by and large, limits what the government can do. The biggest exception to that is the 13th Amendment, which prohibits slavery. And so if you own a slave, that could be unconstitutional. Now, the first 10 amendments apply specifically to the federal government. The federal government cannot impede upon your right to practice your religion as you want, your right to free speech, your right to all of these rights that we have, the right to the press, right? All these things. What about the states? Well, after the Civil War, there was almost like a second constitution because the Civil War amendments changed the balance between what the federal government could do and what the state governments could do. And with the 14th Amendment in particular, it tried to incorporate a lot of these rights that the federal government were required to protect and not infringe upon, and apply that also to the states. For our purposes, the 14th Amendment says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So there's a lot more in the 14th Amendment. This is the part that we need to focus on because it says specifically that the people born here or naturalized here, subject to the jurisdiction here, are citizens of the U.S. and citizens of their state where they reside. So President Trump is coming out and arguing that the 14th Amendment has been misconstrued and stretched too far, and that it shouldn't apply to children born in the United States from undocumented immigrants. Now, where is he getting this from? Well, you saw yourself the text of the 14th Amendment. Does it say anything about immigrants, children of immigrants, undocumented immigrants, illegal aliens, whatever you want to call them? Does it say anything about that? No. So when I teach constitutional law, I always tell my students, it doesn't matter what the Constitution says. And then they all gasp, like, oh my gosh, is my constitutional law saying that? And then I have their attention. And then I say, all that matters is what the Supreme Court, the majority of the justices of the Supreme Court, say the Constitution says. Easy example. Does the Constitution say anything about a right to privacy? No. Has all these other rights, but it doesn't say that anybody has a right to privacy. Now, the Supreme Court for decades and decades has said, maybe you can't see it, but we have a special microscope. And we see that there is privacy there. And the Constitution, it says all these other things, but you put them all together, you put them in a blender, and guess what? There's also a right to privacy for an individual. So what we really have to look at is what the Supreme Court has said the 14th Amendment, in this clause of the 14th Amendment, means. Because ultimately, everybody knows, Trump on one side, the ACLU on the other side, everybody knows this will likely, if Trump does anything, if he gets the Senate to act, gets Congress to pass a bill, if he signs an executive order, I mean, this is going to go up to the Supreme Court. So our starting place is Dred Scott versus Sanford. And Dred Scott was decided even before the 14th Amendment. And in fact, the 14th Amendment was in large part a reaction to Dred Scott. So Dred Scott was a slave in Missouri, and he resided in the free state of Illinois from 1833 to 1843, and in the Louisiana Territory where slavery was forbidden by the Missouri Compromise of 1820. Then he returns to Missouri, and he files a lawsuit in Missouri claiming that he should be free, that his residence in the free territory now made him a free man. He loses in state court and brings a new suit in federal court. His former master or current master at his back or whatever, he's saying no, that anybody who comes from Africa or is descendant of slaves cannot be a citizen under Article 3 of the Constitution. So the court had to deal with this question: was Dred Scott a free man or a piece of property? What a crazy question that the Supreme Court had to deal with. And it was a 7-2 decision. The majority opinion was issued by Justice Taney, Robert B. Taney. And the majority held that their words, quote, a Negro whose ancestors were imported into the country and sold as slaves, whether enslaved or free, could not be an American citizen, and therefore did not have standing to even sue in federal court. And therefore the court lacked jurisdiction to even deal with the question, and the Supreme Court dismisses this case on simple procedural grounds. There was a dissent by Justice John McLean, and he said that men of African descent would be citizens. Perhaps they should be citizens because they already had a right to vote in 5 states. Okay, for our purposes, we follow the majority of the Supreme Court. So dissents are there when justices disagree, but if they can't convince their colleagues to be a majority, then it's kind of, it's just there. So the Supreme Court decides, after Dred Scott unsuccessfully sues for his freedom, the Chief Justice said that African Americans cannot be citizens of the United States and had no rights which the white man was bound to respect. That's a quote from the decision. And what do when the Supreme Court, who's the ultimate arbiter of what the Constitution says, does something that you're not happy with? Well, you're kind of stuck unless you can change the Constitution. So that's what Congress did. Passed by Congress on June 13, 1866, and ratified July 9th, 1868, the 14th Amendment was specifically designed to overturn this decision and define citizenship. And so it extended the liberties and rights granted by the Bill of Rights to formerly enslaved people. In fact, when the 14th Amendment was ratified in 1868, as part of these Reconstruction amendments that ended slavery, really the main purpose of the Birthright Citizenship Clause was to clarify the right of citizenship that it extended to freed slaves. Now, it doesn't extend to everybody, right? Because there's this other clause that we see in the 14th Amendment that says subject to the jurisdiction thereof, right? We saw that earlier. So what does that mean? That's really where Trump is kind of trying to nitpick and say, well, oh, look, illegal immigrants aren't subject to the jurisdiction thereof, and therefore they shouldn't be citizens. Well, we could say that if you look at the history, there are at least two clear examples of people who are not subject to the jurisdiction of the United States. There are diplomats and their children, right? They don't become, if a diplomat has a baby in the United States, that baby does not become a United States citizen. And perhaps even more shockingly, at the time of the 14th Amendment, Native Americans were not recognized as part of the American population subject to the jurisdiction thereof, and so they were not considered citizens. So now we fast forward 30 years. In 1898, 30 years after the 14th Amendment was adopted, the Supreme Court had a chance to really look at what it meant for the first time since Dred Scott and subsequently the 14th Amendment was passed. And there was this case, United States versus Wong Kim Arc. Wong Kim Arc was an American-born son of Chinese immigrants. And at the time, there was a law, the Chinese Exclusion Act. Actually, it was a set of laws, the Chinese Exclusion Acts. And they denied citizenship to Chinese immigrants. And there was also a treaty that was in effect that had the effect of saying that no Chinese subject in the United States could become a naturalized citizen. Well, Wong Kim Arc was born in San Francisco. Parents were both Chinese citizens who resided in the United States at that time. So he turns age 21 and returned to China to visit his parents, who had previously resided in the United States for 2 decades. Then he comes back to the United States and he's denied entry on the grounds that he's not a citizen. And of course he sues. And the Supreme Court has to deal with this question. A child born in the United States to Chinese parents who are permanent residents, who are lawful permanent residents, but not United States citizens. Does this person qualify as a citizen under the Citizenship Clause of the 14th Amendment? Well, the Supreme Court said that because Wong was born in the United States and his parents were not employed as diplomats or any official capacity by the Chinese government, that the Citizenship Clause of the 14th Amendment automatically made him a United States citizen. This was a 6-2 decision, so the majority, 6 justices, and Justice Gray authors the decision, in which the court established the parameters for the concept known as jus soli, that citizenship of children born in the United States simply by virtue of being born on the soil, even to non-citizens. And Justice Gray, writing for the majority, says, quote, "The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, in the allegiance and under the protection of the country, including all children here born of resident aliens." So it's really fascinating, right? Because at the time, there were, as we said, laws against Asian immigrants. They were really the first immigrants in the United States that were not considered white. And so they were treated differently, they were taxed differently, they were stripped of different rights. And Wong Kim Arc, with the assistance of the Chinese Consolidated Benevolent Association, sues the federal government and says, wait a minute, I should be allowed to be a citizen based on the language of the 14th Amendment. And the Supreme Court agrees, right? And because of this case, United States versus Wong Kim Arc, this case really remains the first defining legal decision that's made under the banner of birthright citizenship. Now, of course, perhaps the biggest difference, though, is that his parents were legally in the United States when they had him. Okay. In 1982, this kind of gets expanded. There was a case that made clear that the 14th Amendment also applies to children who were born to undocumented immigrants. And this was the case of Plyler v. Doe. Prior to the Plyler decision, the Supreme Court had never addressed the question of whether undocumented immigrants could seek 14th Amendment equal protection. It was always based on documented legal immigrants. Now we get to June 15th, 1982, and the Supreme Court, by a 5-4 margin, says that undocumented immigrants also have certain protections. There was a Texas statute that withheld from local school districts any state funds for the education of children who were not legally admitted into the United States, and which authorized local school districts to deny enrollment to these children. This goes to the Supreme Court, and the Supreme Court says, no, this is a violation of the Equal Protection Clause of the 14th Amendment. So this was a class action lawsuit that was filed in 1977 on behalf of a group of school-age children of Mexican origin who could not establish that they had been legally admitted to the United States, and the action complained of the exclusion of these children from public schools. And really, this focused on the equal protection part of the 14th Amendment, where that part says that no state shall deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And the state of Texas argued that because these people, their parents came illegally into the country, they weren't legal immigrants, and they're therefore not persons within the jurisdiction as the section of the 14th Amendment requires. And the court rejected that argument. The court says, whatever his status under the immigration laws, an alien is surely a person in any ordinary sense of that term. Aliens, even aliens whose presence in this country is unlawful, have long been regarded as persons guaranteed due process of law by the 5th and 14th Amendments. Indeed, we have clearly held that the Fifth Amendment protects aliens whose presence in this country is unlawful from invidious discrimination by the federal government. And then focusing on the due process part of the amendment, the court says we have never suggested that the class of persons who might avail themselves of the equal protection guarantee is less than coextensive with that entitled to due process. On the contrary, we have recognized that both provisions were fashioned to protect an individual class of persons and to reach every exercise of state authority. Then it goes even further and says how the 14th Amendment is not even confined to the protection of citizens. It just says, nor shall any state deprive any person of life, liberty, or property without due process or equal protection of the laws. So the court says, quoting an earlier decision, that these provisions are universal in their application to all persons within the territorial jurisdiction without regard to any differences of race, of color, or of nationality. And the protection of the laws is a pledge of the protection of equal rights. Further on, there's language that says that although the congressional debate concerning the 14th Amendment was limited in paragraph 1 of the 14th Amendment, that debate clearly confirms the understanding that the phrase within its jurisdiction was intended in a broad sense to offer the guarantee of equal protection to all within a state's boundaries and to all upon whom the state would impose the obligations of its laws. It appears from those debates that Congress, by using the phrase person within its jurisdiction, sought expressly to ensure that the equal protection of the laws was provided to the alien population. And therefore, later on in the decision, the court says that a person's initial entry into a state or into the United States was unlawful, and that he may, for that reason, be expelled, cannot negate the simple fact of his presence within the state's territorial perimeter. Given such presence, he is subject to the full range of obligations imposed by the state's civil and criminal laws, and until he leaves the jurisdiction, either voluntarily or involuntarily, in accordance with the Constitution and laws of the United States, he is entitled to the equal protection of the laws that a state may choose to establish. So the court says, based on the Equal Protection Clause in this case, that a state could not enact a discriminatory classification, quote, merely by defining a disfavored group as non-resident. And there's a lot of language in this decision basically ripping on Texas and saying that they do have an obligation to educate these children. They can't keep them out of the public schools, even though they came illegally. It says, for example, it is difficult to understand precisely what the state hopes to achieve by promoting the creation and perpetuation of a subclass of illiterates within our boundaries, surely adding to the problems and costs of unemployment, welfare, and crime. So, this is where we find ourselves now. President Trump is really trying to end this interpretation of the 14th Amendment. It's extremely hard to amend the Constitution. Most likely, we're not going to amend the Constitution to specifically say birthright citizenship is hereby canceled. It's much easier to amend state constitutions, very difficult to amend the federal Constitution. If President Trump signs an executive order or finds allies in Congress to pass a law, it will inevitably end up in the courts, and the courts will have to determine whether the 14th Amendment actually does protect birthright citizenship. As we know, the court, as it currently stands, has been pretty friendly to Trump. They could do what they did with abortion. They could say, look, we're looking at Roe v. Wade. When that was decided, it was wrong. And we're looking straight at the text of the Constitution, and the text doesn't say anything about this being protected. You never know how they're going to rule, but hopefully I've given you the background and the legal analysis that you need to look and have a good sense of the key issues at play.